Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Protection and Utilization of Public Funded Intellectual Property Bill 2008. It seeks to provide a legal framework for disclosure of scientific innovation made due to government funds. To discuss the issue, I have with me Dr. Sudhir Kochar, National Coordinator, Basic and Strategic Research in Frontier Areas of Agricultural Research, and Mr. J. Sai Deepak, Advocate. Now for the headlines. The bill makes it mandatory for scientists to share public funded innovation. The bill seeks to exempt scholarship and fellowships. And it proposes penalty for scientists not disclosing innovation. The Protection and Utilization of Public Funded Intellectual Property Bill makes it mandatory for scientists to share with the government innovation which has resulted due to funding provided by the government. But the proposed law will not apply to innovations resulting due to scholarship, fellowship and grant given by the government or for educational purposes.
The government spends huge resources in funding research projects, but as of now, it does not have a legal framework within which it is necessary for scientists to patent his innovation. Moreover, there is no law for transfer of technology for public funded innovations, because of which India has a poor ranking in the innovation ranking of the world. To plug the loopholes, the government proposes Protection and Utilization of Public Funded Intellectual Property Bill. The bill makes it obligatory for scientists getting public money to patent what is patentable.
It is very difficult if you funded a project to a scientist and tomorrow if you say what is the benefit to that from that project to the society, it may not necessarily be possible to collect every time. So, providing public funds to make scientific discoveries and making utility of that in terms of making utilization of that for the benefit of the society are not necessarily directly linked.
According to the bill, intellectual property means intangible property including trademark, patent, design and plant variety. The scientist creating the innovation will be entitled to 30% of net royalties. But before this happens, a funding agreement will now be mandatory for institutions demanding research purpose grants. Also, the scientist and research organization may have to adhere to prescribed duties. The scientist will have to inform the research institution immediately after the creation of an innovation. The scientist will not be authorized to disclose the innovation without notice of 60 days to the institution or government. The institution will have to list the countries where it intends to retain title of the innovation, and the title in all other countries will vest with the government. The government retains the right of refusing title on certain grounds. The institution must obtain permission from the government before it can assign its patent rights to any person or body. The institution will not have the right to grant use of patent to any foreign manufacturer.
In certain fields of technology, research is linear in nature, which means from one step I proceed to the second step, third step, sequential research, that's how it's called. So there is a possibility I might have arrived at the first step, which in itself may be patentable. But if I go to the second step, both these things could be protected together. If I go to the third step, I could come out with a proper system, an ecosystem in place. Now for this to happen, sometimes it takes months and years. So 60 days I really don't think is the time frame that we should be looking at. We shouldn't put our scientific community under this kind of unreasonable pressure.
India spends less than 1% of its gross domestic product on research and development, compared to over 2% of GDP by most developed countries. Of the total money spent on R&D in India, 3/4 is paid by the government. Subina Roy, Rajya Sabha TV.
The Parliamentary Standing Committee is of the view that the bill needs to maintain a balance between the social sector and the market-driven model. Therefore, it proposes that a uniform policy on licensing cannot be adopted. My question to you, sir, is, does the bill stress too much on commercialization of scientific innovation?
Of course, in the present form it does, whereas basically what I feel is that the bill should have asked for the ownership part, the execution of seeking right, and then utilization of that intellectual property right. In the present form, it talks of intellectual property, but it does not talk of intellectual property right. So, the confusion is basically between what subsists, because intellectual property always subsists whenever some work is created, and the grant is not a natural right. I mean, it is subject to the law. So, the law of land only decides whether one gets a grant over that intellectual property that subsists or not. So, this is the dilemma in the bill basically, but according to me.
But definitely, according to you, the stress of commercialization, is that acceptable at this point of time, and the way we have the innovation sector organized, the way it is organized right now, do you think it is desirable to have such commercialization mandatory built into the system of scientific innovation?
Wherever we need to progress in this direction, whereas, but there should not be an emphasis on the commercialization per se, because the point is to identify the commercializable intellectual property and then to work on it. What we have seen from records anywhere and I mean within the country and elsewhere, that we will not be able to get as much commercialization success as we anticipate from this bill.
So, you mean to say they should be segregated, commercialization is one aspect, scientific innovation is another?
Definitely.
And there should not be any.
And then above that also there can be some intellectual property on which we may seek right, still we want to use it in public domain.
I will bring in Mr. Deepak. Sir, the issues of basically allowing the scientific community to innovate and a portion of it to be commercialized. The bill in its statements and objects and reason, that is what it seeks to do, but without providing any mechanism as to how it will happen. And it burdens the scientific community with the pressure of doing everything on its own, right? Innovate and then commercialize.
Right. I think that a certain amount of emphasis on commercialization of scientific innovation is not bad per se, but the mechanism that we propose or the way or the means that we choose to go about that particular objective, I think is the problem with the bill. Because there seems to be a distinct impression that one gets after reading the bill, that it is all about protecting or creating intellectual property which is let's say proprietary in nature, which I think could be a bit of a burden on the scientific community, because one thing is scientific community is not a homogeneous entity. Some of them could be engaged in pure and basic research, some of them could be engaged in technological research. So, are we saying that even something that is that falls within the realm of, let's say, pure and basic research must actually be protected by intellectual property rights when it could have larger implications for, let's say, progress of science itself? That's one question. The second thing is, how do you expect, let's say, a scientist who's basically, let's say, a creator or an innovator to grapple with so many administrative issues? Because most of the scientists in all these institutions have two things. One, they have to teach their students, and second, they also have to undertake some kind of publications on their own, because that is some kind of a mandate that their own universities require, that they must have regular publications at regular points in time. Apart from that, you also want them to take up this particular activity. I don't think it's impossible, but I think if that be the case, either increase the number of people in the scientific establishment so that you have enough people doing different things. Apart from that, also create an infrastructure to manage different administrative aspects instead of making the creator responsible for all of these things.
I get it. On the commercialization bit, quickly, commercialization, it doesn't create any via media, because if the scientist is supposed to market his innovation.
Right.
It just can't happen. You can't have a scientific community also getting involved into marketing.
Right.
So we have to create a go-between, and what's your suggestion on that?
From the experience of other jurisdictions or other regimes, I think one way of doing it could be to have technology transfer offices. But then creation of technology transfer offices involves creation of additional infrastructure in universities, which means they again have to spend their money there. And we also know that funds is not something that they have the luxury of, Indian institutions at least, because they keep asking for more funds from the government on an yearly basis. So what could probably done is that if there are a cluster of institutions which are, let's say, based around a couple of universities, or let's say they're in each other's vicinity, you could have a common technology transfer office, which takes upon itself of collecting information of statutory or, let's say, commercializable or commerciable intellectual property from these institutions and vends it on behalf of these institutions to industries. The alternative could also be to ramp up the industry-institution interaction within these universities itself.
Like the Bombay IIT.
Bombay IIT. But the only problem then could be that everything that the industry does could become, the university does could become industry-oriented, as opposed to being society-oriented in certain ways.
Yeah. Is that the way to go?
Of course, partly it is correct. From scientist point of view, the perception is that ultimately anything that has been perceived, anything that has been executed and experimented upon to solve a problem that is of immediate use or future use is to be transferred. So previously what we have been doing is we have been using the term extension because all the technology was in the public domain. And from the public domain that technology had to be transferred. So similarly now in the exclusive regime, because now we are part of the WTO regime, and after 1/1/2005 when product regime has come into being, so it is more or less a compulsion on the part of the researchers or also scientific the R&D community to see to it that more and more of products are available in the market, and we are there as competitive persons in the market.
Right. So it's time for us to head into a break. When we come back, we will talk about the penalties that are proposed in the bill. Welcome back. Any institution violating the agreement will have to pay up the grant amount with penal interest on it, and may also include fine up to half the grant. If the scientist does not disclose information, he will not be given royalty and will be punished with a fine.
Bars an institution from publicly disclosing or publishing the innovation till an application for its protection has been made in the countries it intends to retain the title, especially if there is commercial potential.
The main aim is to make any activity commercially viable, and as long as it's not economically viable or it does not generate funds for its own sustenance, it may not work. So this policy broadly brings out the need for commercializing the innovations and the research, the patents, other things, so that on a longer term it creates funds for itself to be reinvested in these, and the fruits of innovation is shared by the larger number of people.
The bill provides for the creation of an intellectual property management committee in institutions which will be receiving government fund for research. And this committee will identify, assess, document and protect the innovation having commercial potential. If the institution violates the agreement, the government will recover the grant amount with a penal interest of 10% per annum. It may also be punished with a fine of up to 50% of the grant amount. If the scientist does not disclose information, he will not be eligible for royalty and will be punished with a fine of up to 25% of grant received by the institution.
What is actually has to have the discoveries that scientists make to be consolidated in terms of a thematic information, and then he makes that as a logical conclusion, and that could be disclosed. The important thing is that penalties associated with that creates the problem.
Once this bill is approved by the parliament, scientists will not be able to hold the intellectual property thinking that he owns it. This bill is likely to minimize the tendency by the knowledge community to hoard knowledge. Since the bill allows transfer of technology, indigenous companies are likely to benefit. Subina Roy, Rajya Sabha TV.
The Parliamentary Standing Committee recommends that the penal provisions should be more moderate so that it does not deter genuine researchers and scientists. My question to you, Mr. Deepak, is the penalty clause really required? Can the institution or the scientist in India today really afford not to disclose when it is taking public fund for it? Is that a threat, or is that a reality, or it's just purely notional?
I think we must draw a fine line between insisting on transparency and creating an atmosphere of fear, or let's say a fear of sanction in the scientific community. Transparency could be achieved by other means, but I really don't think that you would get your goals by asking the scientific community to regularly cough up information. Because as long as you have, let's say, a procedure which documents the use of the public funds, and you have, let's say, a system of reporting back as to what is the progress that is made, and you have a system where, let's say, the institution realizes that deadlines are intended to be met, I think that is sufficient. But to actually go to the extent of imposing sanctions of this nature, I think would really deter quite a few people from joining public institutions. And when we already have a paucity of hands in public institutions and researchers, why would you want to create this kind of a system in the first place?
So not really required.
Not really required.
The penal clauses.
No, I don't
and the standing committee is correct in
asking
saying
for a moderation. Absolutely.
Moderation.
Yes.
My question to you is, how important is transparency and accountability vis-a-vis commercialization? Which of the two aspects are more relevant for the community which you are a part of?
To me, any research result which is out lab or out field, it is still, you can say, an immature product. We need to first validate it. So that validation is very, very important. Unless until that validation is there, the scientist having known whether it is really an IP worth protecting or not, it's difficult for him, and you ask him to decide within 30 days whether it is protectable or not. So there are serious issues which needs to be relooked. But as far as penalty part is concerned, what I see is that in the Act there is one clause which is a very broad spectrum, but it can be used to the defense of all, that no suit or other legal proceedings shall lie against any person in respect of anything which is in good faith done or intended to be done in pursuance of this Act.
Provided it can be substantiated.
Since there is no core institutional mechanism built, so that means it can be applied on either side.
Yes.
So that is one thing. So there are weaknesses, and I mean there are interpretations within the bill which is a normal course of action. One more bigger weakness that which I see is that there is one onus on the institute to have their audited accounts, and second onus is on the committee. And everything is left to the committee without having to describe that as to what is committee, how it will be empowered, how it can take action, and whether the institute will be obliged to spare some of their shining scientists only to man that committee. So these are some of the additional issues.
Okay, accountability and transparency in the present system as it is there, do you think more is required, or whatever is existing is sufficient?
It is definitely required, but there is a diametric.
Does it exist?
Yeah, to quite an extent, it exists as far as the scientific, I mean, barring aside the personal relationship and other, where, I mean, narrow interpretations can be made at point of time. But broadly, we are moving in that direction, because many of the organizations, they are having their proper intellectual property management guidelines in place.
Do we really require this piece of legislation? The broad question. Beyond addressing issues of accountability and transparency, does this bill actually achieve anything else?
Honestly speaking, there are certain aspects of the bill which are required, but the legislation itself, I have my own reservations about its, let's say, requirement in the first place. Because in my knowledge, what we should probably have is a mechanism that gives an impetus to research and research institutions, and then there must be a mechanism to monitor the progress in these institutions, followed by an emphasis on transparency, as opposed to looking at intellectual property as the only goal or as the only means of achieving
public fund.
transparency.
Yes, yeah. Okay. On that note, it's time for us to head into a break. When we come back, we will show you an interview with Amit Datta, partner, Luthra & Luthra law firm. Welcome back. My colleague Aruna Thakur spoke to partner Luthra & Luthra law firm, Mr. Amit Datta, and tried to get his point of view.
So how do you see the proposed current amendment?
The commercialization further of innovation has largely taken a back seat, and this needed to get a boost. And from that perspective, I think the aspect of the publicly funded innovations bill that will change this or will give an impetus to innovation is primarily on the fact that it incentivizes rather the inventor, the scientist in a publicly funded institution to innovate more, and gives him that assurance or rather reassurance that his innovation will not only benefit the country, but he will also derive a personal benefit from the commercialization of his innovations.
If the bill becomes an act, what will be its impact on the scientists who are working in the public funded institutions?
That scientists can actually truly be called real stakeholders in their innovations, even as a part of government institutions now. There has always been a need that government institutions, and one quick example is that innovations that have come out, say, from the US, innovations that have come out from the great innovator economies, say, Europe, for instance, were always arising because of a very close linkage between industry and government. And that precisely, and so therefore our bill or the bill currently being proposed mirrors the Bayh-Dole amendment, for instance, in the American law. So from that perspective, innovators in India will become stakeholders, will benefit, and hence the incentive to protecting, to innovate more, will definitely be, something that will be a manifold increase, or we will see that manifold increase. Most importantly, I think it will also allow institutions to better realize the commercial potential of those innovations.
Do you find any loophole in the bill?
The fact that the bill mirrored too much of what the Bayh-Dole legislation said, or was rather did not take Indian conditions into account.
The bill divests the creator of any discretionary power to decide whether an innovation should be patented or left in the public domain. My question to you, sir, is on the confidentiality versus RTI issue and also on the designated country issue. What is it that you would like to add?
My point was that it's not necessary that everything needs to be patented or copyrighted or protected. There is protection for undisclosed information, which is one of the standards of IPR. So there will be certainly certain information which should be kept confidential, and that should also be a part of the disclosure requirement if at all this bill has to go through.
Okay.
Because if the scientist discloses that, well, this is the information which would be in the interest to be kept confidential, and the government agrees to that, that needs to be done accordingly. What happens is that on the other side, the RTI, it provides for getting any information and every information at any point of time, and if during that process that information
is asked for,
there is no safeguard.
No ground to deny.
There is no safeguard for that. And second one is that there is so much of emphasis on the designated countries. So it appears as if we are only concerned about protection outside, whereas India itself is such a big market that even the domestic players, they need to learn how to go about the business in the exclusive domain.
Right.
So that is why protection within the country is important. And second part is that if you have to have so much of designated countries into picture, why not to simply ask for one PCT application? Because PCT application itself gives you the solution. The additional point which you asked me was that what additional I want to say? Additionally, I want to say is that we have not given any preambular statements in this bill, which was there in the initial version. What particularly is required to be given as a categorical statement is that hardly few of the inventions will be protectable or the works will be protectable, and further to that, few of those will be commercializable.
Okay, I get it. Now I'll bring Mr. Deepak in. The starting point of the entire legislation, whether this bill is really required, does it fulfill its goal, and what should be the starting point of this kind of legislation?
See, as far as this discourse is concerned, if you really want a comprehensive approach to this, I think the current bill which has been proposed in 2012, the Universities of Research and Innovation Bill, should be the starting point of discussion, where we create an ecosystem or an environment of innovation, and where we tell people that if you need to survive in today's market, innovation must be the name of the game. So once you have done that, and once you have achieved, let's say, an atmosphere where everybody is trying to create and innovate, that is when you actually start emphasizing on protection of the particular innovation. That must be the second step. That said, there appears to be this distinct impression that unless and until you have a legislation of this nature, there is absolutely no way of protecting intellectual property that is created or that comes out of public funds, which is not the case at all. Because the existing rules, the existing principles that are there in each of these IP legislations, such as the Patents Act or the Copyright Act or the Trademarks Act or the Industrial Designs Act, they themselves are absolutely
sufficient to take care of it.
And if industries or let's say our institutions were to formulate their own internal guidelines, keeping these legislations in mind, I think they would more or less achieve the goal.
We don't really require
we don't
this.
Really require this.
Thank you, sir, for joining us on this show and discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.